Good morning, everyone. I'm Cindy Merzon, Director of the Cal Coastal Small Business Development Center, also known as the SBDC. Thank you for joining us today. We are pleased to partner with the Monterey County Business Council to offer these time-sensitive topics to you via the webinar every Friday. The Monterey County Business Council is a membership-based organization that works together with private businesses, the public sector, and nonprofit organizations, and you can find a membership application on their website at mcbc.biz. The SBDC is a business service organization that provides no-cost one-on-one business consulting, workshops, and webinars to businesses in Monterey and San Benito counties who register for our services at calcoastalsbdc.com. We are in our 8th week of meeting our commitment to regularly communicate with you about important COVID-19 topics tied to businesses. When you registered for today's session, you gave us your email address. We will have more of these free webinars over the next few weeks, and we'll let you know of the upcoming discussions on small business opportunities, such as the one we're having today. I do want to thank our partners, again, the Monterey County Business Council, the SBDC team, the City of Salinas, the County of Monterey, the U.S. Small Business Administration, and the California Governor's Office of Business and Economic Development. Additionally, I want to give a big shout out to Luis Alvarez of Alvarez Technology Group. Luis and his team are over there producing the webinar today for us and trying to keep us out of trouble. I want to encourage you to ask as many questions as you want today. There's a chat feature on the right side of your screen where you can ask questions. We are also recording this webinar and we'll send you a link with the recording so that you can review today's class later if you missed something. We will also send out the contact information for our speakers. Here's the agenda. The topic today is risk management for small business during COVID-19. The focus will be on business interruption insurance, COVID-19 related and future needs, and limiting COVID-19 related liabilities when opening your business. Our esteemed speakers are Anthony Castellan Mendoza and Mike Masuda, both attorneys with Nolan Hammerly, Etienne, and Haas. Welcome, Tony and Mike. Take it away, Tony.
Hi, everyone. My name is Anthony Castellan Mendoza. I'm an associate attorney at Nolan Hammerly, and I'm joined with the head of the litigation unit, Mike Masuda. And today what we're going to be talking about is two separate issues. The first being business interruption insurance. What is it? What does it cover? As well as potential liability that small businesses face as these stay-at-home orders start to loosen up and the economy starts to return to normal, and things to look out for. And so we have a PowerPoint, and let me share that. There we go. Okay. All right, and just as a preface before we begin, what we talk about is not legal advice. It's solely for educational purposes. And if you have any specific questions that may pertain to your own business, you should seek the advice of legal counsel. And so I'll be handling the business interruption insurance side of this presentation. And the main questions that I want to answer are, first off, what is business interruption insurance? What does it cover? What doesn't it cover? And how does COVID-19 impact this business interruption insurance? And so the main thrust of what business interruption insurance is, it insures your loss of business income during a shutdown. Most businesses have insurance that covers their property, damage to it, individual items that might be contained in their business, but a lot of people don't know that you can actually insure any loss of business income during a slowdown or temporary closure. Just a couple of notes, it's not a standalone insurance, meaning that you can't buy it independent of a bundle or a package. It's an option that you have to sign up for. And so many people may or may not have it and not even know it. So you should review your policies if you have business insurance, because it may be in there. And I know I'm going to repeat this several times throughout my half of the presentation, but the text of the policy is crucial in this instance, especially when we're talking about COVID-19 as well as stay-at-home orders, because the text of your policy will control. So I encourage you to review your policy. You may be covered or you may not, depending on what it says. And the goal of this presentation is just to discuss the general ideas. So next, this is just a sample form of what a business income coverage form may look like. And what I want to talk about first, what is business income? Most people think it's just simply the income that you make on a month-to-month basis, but for most business interruption insurance policies, they give you an option to cover three potential areas. First, your net income, which is net profit or loss before income tax that you would have obtained during your closure. Second, it could also include payroll expenses, meaning that the insurance company will cover any payroll expenses that you had to pay during that closure or temporary slowdown. And it can also include rent. And so for the first point as to net income, if you have business interruption insurance or you're thinking about obtaining it, one thing that you have to keep in mind is if you file a claim, they're going to want to see receipts. They're going to want to see records of how much money you've been making for the past several months or the past year, so they can determine how much money you would have, how much income you would have obtained during that closure. Say if you're closed for April, May, and June, and you have receipts or proof to show for income for January, February, March, some insurance companies will want to see income or receipts of income from the prior year for those 3 months to sort of see, well, sure, you made income in January, February, March, but how much income would you have made during these months? So let's look at past years to make that determination. So it's very important that if you're thinking about getting this type of insurance, or if you have it, to maintain those sorts of records going forward. Also same for payroll expenses and rent, just keeping track of records. That's the key here. Okay. So I have pasted on this slideshow 3 areas which business interruption insurance applies. The first being civil authority, and we're going to talk about that later. The second being that you had to close your shop for some event that occurred. That's what we're going to focus on primarily in this presentation. The third being that if you had to close your business because there's some construction or you're adding on to the business, or there's some construction going on outside where you had to close temporarily, that's where the third avenue comes into play. But for this presentation, we're going to be talking primarily about the civil authority coverage as well as covered cause of loss term at the bottom. And so generally most policies have this type of language. We will pay for the actual loss of business income you sustained due to the necessary suspension of your operations during the period of restoration. This is a lot of text. Don't worry, I'm going to break it down. The suspension must be caused by direct physical loss of or damage to property at the premises which are described in the declarations. The loss or damage must be caused by or result from a covered cause of loss. Now, that's a lot of text, and I know, but essentially, what we can break that down to are there are 4 things that you have to show in order to file a claim and receive coverage under business interruption insurance. The first being, obviously, a loss of business income. If you didn't suffer any loss of business income, there's nothing to claim. The second you have to show is that you lost that business income because of a suspension of business operations. And note at the bottom, as I say, suspension can mean a slowdown or temporary closure. Again, it depends on what your policy says, but most policies also include slowdown. The last 2 points are what the rest of this presentation are going to focus on. Because of direct physical loss of or damage to property at the premises. And that loss of business income must be caused by a covered cause of loss. And so what I want to focus on, what does that mean first? What does covered cause of loss mean in a business interruption insurance context? And it's pretty straightforward. You're going to have a covered cause of loss form. There are 3 main forms, the CP 1010, and these are forms that you can look up online, and it'll list what has to happen, what event has to happen for you to be covered under this type of insurance. And the basic coverage includes fire, lightning, explosion, smoke, windstorm, hail, riot, civil commotion, aircraft, vehicles, vandalism, sprinkler leakage, sinkhole collapse, volcanic action. If any of those events happen, and you have to close your business because of it, then the business interruption insurance would kick in and cover your loss of business income. But in the COVID-19, from the COVID-19 perspective, there is no virus coverage under this. So if you have the basic business interruption insurance policy, you probably would not be covered in this context because the damage or loss of business income was not caused by, in this case, a pandemic or a virus, and that's not covered in this basic cause of loss form. Okay, well, there's a more advanced coverage. It's called broad covered cause of loss. It's a CP 1020. And in this form, it adds falling objects, weight of snow, ice, or sleet, water damage, and some various other collapse from various other causes. But still, there is no virus coverage. And like I said at the beginning, the text of your policy will control. So it's crucial that if you have business interruption insurance, to read it to see if you are covered. And if you don't, and you're concerned about future pandemics or future orders that may come down, to really sit down with either an attorney or an insurance broker to go over your risks and figure out which coverage is best suited for your business. Now, there is one final covered cause of loss policy, and it's called an all-risk policy. And like its name suggests, it covers all losses, except those which are specifically excluded. And so in the COVID-19, from the COVID-19 perspective, if you are concerned about future closures or future, perhaps, pandemics, your best bet would be an all-risk policy because you may be covered. But before we can even talk about that, we have to talk about, well, what is excluded? Now, each policy will have a specific list of exclusions, meaning the insurance company will not cover any business income loss if it were caused by an event on that exclusions list. And there are really only 3 events that you have to look out for in terms of virus coverage. The first is fungus, wet rot, dry rot bacteria. If you have renter's insurance or homeowner's insurance, you may be familiar with this text. If that is listed in the specific exclusion, the fungus, wet rot, dry rot, or bacteria, you're safe because a virus is not specifically included in that list of exclusions. A virus is not a bacteria, it's not dry rot, it's not wet rot, it's not fungus. So you're good there. But in the last 2 are what you have to look out for. If the specific exclusion states exclusion for loss due to virus or bacteria, or if there's a pandemic or epidemic exclusion, then even if you have an all-risk policy, because those exclusions are there, the insurance company would not cover you. And so again, the text of your policy is crucial. It's very important. You must review it to see if coverage is available in this area. And just an interesting note, the pandemic and epidemic exclusion, a lot of insurance companies started to include that in their exclusions list after the SARS outbreak in the early 2000s. So again, review your policy and see if you are covered. Now, the next question that we have to ask, well, if we go back, let's go back. So we discussed covered cause of loss, but what about direct physical loss of or damage to property of the premise? That's the third point. Basically, what insurance companies are requiring is that if there is some event that is caused by a covered cause of loss, that it must cause some direct physical loss or damage to your business property. Well, that poses sort of an interesting issue because viruses they're not like fires, they're not like floods, they don't cause physical damage. In other states, courts tend to interpret direct physical loss very loosely. I think in New Jersey, there's a case out of New Jersey which says like the odor of methamphetamine in a home constitutes a direct physical loss. But in California, courts tend to define this term very narrowly. In fact, most cases require a tangible physical change or loss. An example that I put there is that computer data is not a direct physical loss. And so at first glance, it looks, oh gosh, viruses, that's not covered because they don't directly cause damage to your property. But then came along the Hughes versus Potomac case. It was decided in 1989. And the facts of the case are interesting because they opened the door to this sort of secondary argument for coverage during this pandemic. And the facts are that it was a homeowner's insurance policy, and the homeowner's insurance policy covers direct physical loss, all direct physical loss of damage to the home. Well, this home was perched on top of a hill. There was a huge rainstorm. It washed out part of the hillside in a rock slide. And essentially, the house was on top of a 30-foot cliff. Half of the house was dangling over a 30-foot cliff. And so the homeowners filed a claim with their insurance company, and the insurance company denied coverage, saying, yeah, the property was damaged, but your house wasn't. There was no direct physical loss to the house. And the appellate court ruled in favor of the homeowners, saying essentially that the home was rendered useless, that there was no reasonable person who would feel safe using that home. And so even though there was no direct physical loss, there was still a loss of the ability to safely use the home. And so this sort of opened up this avenue of, okay, well, perhaps direct physical loss doesn't simply mean tangible damage, but could also mean the ability to safely use it. So many cases which have been filed recently address that argument. They proceed with that argument by saying, okay, well, this virus, this pandemic, has made us close our business because we can no longer safely operate. The virus is very contagious. It has a high chance of getting people sick, and some segments of the population extremely sick. So we've lost the ability to safely use our business. And we're waiting to see how that argument fares in the courts. There is no direct answer yet, but what we do know is that the California Supreme Court has ruled when courts are interpreting insurance policies that they should interpret the policies broadly to afford the greatest possible protection to the policyholder, and that exclusions to those policies must be construed narrowly in favor of coverage. So there is this policy in the court system to interpret insurance policies in your favor if they are vague, if they are general. So that is good news going forward from here. And before I turn it over to Mr. Masuda, there's one more conversation that we have to have regarding civil authority. If you remember back to the beginning, there are three main areas of coverage, first being civil authority. Now, some attorneys who are filing these cases against insurance companies are claiming that this clause would cover the closure of certain businesses. They're basically arguing by saying that, oh no, we didn't close because of the pandemic. We closed because we were required to by these stay-at-home orders. And if you look at the text, and this is just a sample, each civil authority text in every individual policy varies, but the essence of it is, if you have to close your doors because some civil authority prohibits access to your business, meaning the government closes your business, then your business income may be covered. And in that paragraph, we will pay for actual business loss of business income you sustain caused by action of civil authority that prohibits access to the described premises due, and stop there. Because everything past that point varies greatly from policy to policy. In this example, the civil authority requires direct physical loss or damage to the property, and we have to go back around and around in circles in that prior argument. But some policies don't require direct physical loss under civil authority. Some say that simply a civil authority closing your business is sufficient in and of itself. Others don't. I think in more recent examples, the Northern California fires, for example, in the past couple of years where they had to evacuate entire towns and close businesses, that's where this specific clause in the policy came into play as in a more recent example. Again, we're still waiting to see how the courts will come down on this issue of direct physical loss or damage to property. But what we do know is that the courts tend to interpret insurance policies very liberally in favor of coverage. So even if you don't have business interruption insurance, you should look into getting it to see and sit down with an insurance broker to discuss what risks your businesses face if you're afraid of potential future closures, or if you're not particularly scared about the pandemic but just want to insure your business income loss, you should sit down and talk with an insurance broker or an attorney to go over those risks. And if you do have business interruption insurance, look at your policy. You may be covered, you may have been covered during the shutdown, and look at the text of the policy. And so with that, I will turn the presentation over to Mr. Masuda.
Morning, and Anthony, if you put up the first slide. My name's Mike Masuda, and there's an old Chinese proverb that says, may you live in interesting times. I'm not sure if that's a proverb or a curse, but what I want to talk about briefly is how do we manage risk in these interesting times? Now, all of you are experienced in managing risk. You do it every day in your businesses and operations. But we're facing unique risks now that none of us have ever experienced. And there's an old saying that when you manage risk, you should control what you can and be aware of what you cannot control. So let me give you a little vignette of what could happen. One of your employees comes to you and says, I've just tested positive. There's a cascade of issues that can arise from that one incident. Is this employee entitled to workers' compensation? Have you complied with all the Cal-OSHA safety rules? Do you need to quarantine? Do you need to shut down your business? Have any of your customers or clients may have been exposed? Are you able to perform all your contractual obligations if this person has to be sent home? And have you complied with all the government regulations? All from one little statement, I've tested positive. Next slide, Tony. There has been a wave of litigation that has just started, COVID-19 litigation. There was a suit against a manufacturer of hand sanitizer for misrepresentation, saying that it was didn't sanitize as much as it said. They said there's many price gouging cases. Airlines, ticket companies, StubHub have all been sued for refunds because of the cancellation. That's just the tip of the iceberg. So COVID-19 litigation is going to come upon us. And as I always tell my clients, when they're faced with the risk of a legal claim, the first question is, do you have insurance? And insurance is an integral part of your risk management strategy. Next slide, Tony. This is the very first question. Are you covered? Because that is, if you're not covered, it's just as if you didn't have insurance. And there's many, many types of coverages, but there's one type that you don't want. Tony, then next one, please.
The BBC would like to apologize for the following.
Tony.
I'm sorry?
Oh, let's just skip this one. That's all right.
Okay.
Sorry about that. The key is if you have coverage. And there's many different types of policies. There's liability policies, employee practice liability policies, property policies, business interruption, workers' compensation. And it's very important that you're aware of all your policies and coverages and look at them carefully, because as you just saw with Tony, there's a lot of fine print. They're very complex and dense. You may have coverage when you don't think you do. Insurance ease is almost a foreign language. So it's important that you contact your broker or your attorney if you have any questions. And it's important to do this because there are traps that carriers use to avoid coverage. You have to, in certain circumstances, give timely notice to the carrier. You need to have documentation of your claim. So it's important that you have that documentation. And as Tony pointed out, there's exclusions. There's pathogen and virus exclusions that, as he said, were included after the SARS epidemic. So we talked about controlling what you can and to be aware of what you can't. So let's talk about some of the possible legal risks that are now coming forward, but are more unique to this claim. The first one is employment. Workers' compensation. In California, the governor has issued an executive order that if any of your workers come down with the virus, there's a legal presumption that they got it from work and it's a workers' compensation injury. And just compare that when someone in the past would get the flu, no one would really think that's a workers' compensation injury. They got it at home or from a relative, but now it's presumed that you got it from work and it's going to be compensated under workers' comp, which will obviously affect everyone's rates. It's a rebuttable presumption, so the employer can say no, but boy, it raises all kinds of issues of how you prove that. So we're going to see a rise in workers' compensation claims. There's no doubt about that. There has been a rise in claims of disability under the Americans with Disabilities Act and the California state equivalent. For example, what if one of your employees said, I need to work from home? Do you have to do that? Is it a reasonable accommodation? One of your employees says, I want to have plexiglass screens or on my desk. Do you have to do that? Is that a reasonable accommodation? Because is either having the virus or have fear of the virus considered a disability to which you have to have accommodation? It can get worse. There was a recent case where a Walmart employee died of the virus, and now his heirs are suing Walmart because they said he told his manager and his manager didn't take proper precautions. So there's now a wrongful death case. There's cases of discrimination where employers, I shouldn't say you, but employers are laying off or terminating employees who are in the higher risk. And that usually is the same thing as age. And all of a sudden they're saying, you're doing this because of my age, and that's unlawful. There's privacy issues that you have to be aware of. Can you require your employees to take the test? Once we have those tests, generally you can, but it raises some privacy issues. What if one of your employees tells you, I tested positive? Can you reveal that person's name? These are all privacy issues which we now have to deal with. There has been a large amount of whistleblower claims. Someone complains about the virus and they're terminated, and they say it was for whistleblowing. And their wage and hour claims. You have employees working from home and they said, oh, I worked 14 hours that day, I want overtime. That's a wage and hour claim. You all know about premises liability. Next slide, Tony. When someone gets hurt on your property, and it's usually like a slip and fall. Well, customers can now sue you saying that they went to your place of business, got the disease, and it's your fault because you didn't take the proper preventive steps. And the best way to try to avoid that is to follow the CDC guidelines. And you could say, yes, we did. For businesses, one of the real big issues is contractual obligations. Next slide, Tony. And you've heard of this term probably a lot, force majeure. It's a French term for, it means superior, a superior force event. Now, I've been practicing law for over 30 years, and I think I've dealt with a force majeure clause maybe once or twice. It's kind of an arcane term. It's in many contracts, but is now coming to the forefront of litigation. And what it really means legally is has an event occurred which is outside the reasonable control of a party, which prevents that party from performing their contractual obligation. I couldn't deliver this product to you because of the virus, and now I'm excused from breaching the contract. Normally, you would have breached the contract if you can't provide what you promised to do, but the force majeure gives you a way out of that. So these clauses are going to really be the focus of litigation in the future. And so you want to know whether you can invoke it, and you want to know whether the other side, if they haven't performed under their contract with you, can properly invoke it. And the first thing you need to do is see if you even have a force majeure contract clause in any of your contracts, because if you don't waste your time. And if you do, you probably have to have your attorney look at it, because it's going to be in legalese, rather arcane terminology. But if you have all that, just ask yourself these questions. Was the event, the coronavirus, beyond my reasonable control? I think the answer to that is yes. Could you have performed your contractual obligations? Has the virus affected your ability to perform your contractual obligations? Depends, obviously. That's the second question. The third one, and this may be the most important, have you taken all reasonable steps to avoid or mitigate these problems? You can't just say, oh, well, the virus shut me down, I'm not going to do anything about it, and I'm excused from all my contracts. You can't do that. One thing that you should look at right away is if you have a force majeure contract clause, is it oftentimes contains a specific list of events that trigger the clause. And it would be great if you're trying to enforce this clause if it says pandemics, epidemics, pandemics, or diseases will trigger the force majeure clause. If it doesn't, that's something for attorneys to fight about. So if you think this may be something you want to invoke or the other side is invoking, you need to look at your contracts very carefully and read the language and think about whether or not you want to have such clauses in contracts you enter in the future. Either you include them or the other party includes them, and you have to decide whether or not you'd like to have that in your contract. And the final point on this is there are often notice requirements to trigger enforcement of this clause. And so you have to see if you've noticed them in time, and then there's going to be documentation requirements to prove that you actually couldn't perform under the contract. So this could be a very big issue in contractual relationships as we go forward. Another issue, and Tony, next slide, please, is phishing and data security. So this has become a big issue, particularly because our computer systems, our data, our information, our technology is now more susceptible because people are working from home from their personal computers. There's been a huge rise in phishing expeditions. So the CDC has found that many of these phishing expeditions use their name or the WHO. They send you an email with a seemingly legitimate name. So there's some tips on spotting phishing emails. The first is that it may play on your fears or be very urgent. Second, it will ask for personal or financial information under the guise of some other request. They often use odd greetings that we don't use so much before, sir or madam, dear sir or madam, because oftentimes these phishing expeditions come from out of the United States. The fourth one is that they oftentimes have sketchy email addresses, something like COVID or California COVID-19 defense response group. Well, it sounds official, but it sounds also a little bit made up. And the last one, there's often spelling and grammatical errors. So those are just kinds of things to look at and tell your employees to be aware of, particularly if they're working from home. Now, working from home also creates risks of data breaches, and you could be responsible for that. You need to make sure that if your employees are working from home and having access to your confidential information or your customer or client's confidential information, that you have adequate security. Our firm, many of the attorneys and other people are working from home, and we had to take very significant steps to ensure that the information on our computers that are going back and forth from everybody's home, probably 20 or 30 people are working remotely, was all encrypted and couldn't be hacked because we're using our clients' confidential information. And if there is a data breach because one of your employees was working from home, it doesn't matter. You're going to be responsible for that. Here's a little interesting, well, legally we find it interesting tidbit, is on your property insurance. You have property insurance that protects you from being, fires and things like that. Well, there's exclusions in these policies if your building is vacant. Well, what if it's been vacant for 6 weeks because of the COVID virus? There may be exclusion from coverage. So that's just something you need to be aware of. Another thing with property damage is there's claims coming up where property owners are saying, my building has been damaged by the virus. Now, normally you have property damage insurance for fires, flooding, things like that. Well, now people are saying my building is unusable because of the virus. I have to close it down because of the shelter-in-place orders. I can't afford to disinfect it. So those are new claims that are coming. And then the last item of risk is compliance with government regulations. We haven't seen a lot of litigation or claims out of that, but they could be coming. Maybe they'll be reduced as government regulations ease up, but it's still something to be concerned about. Okay, so I've given you kind of the parade of possible horrors. Let me give you a few resources. And there's tons of stuff on the internet, but the CDC has an interim guidance for business employers, which is pretty good. The SBA website has good information. State websites. Your insurance broker is very, very important. There's attorneys who are becoming pretty competent in these issues, and talk to your competitors, other people in your business, and trade groups. There is a lot of information out there. Last slide, Tony. And let me end with kind of a Hallmark card ending, is that we all need to be resilient, and we all need to treat everybody well, and we will all get through this. So thank you.
Thank you, Mike and Tony. We are now open for questions and answers. We have a couple that have come in that have been answered directly, and we have a couple that are pending that we'll read to have you all answer now, Mike and Tony. And if you in the audience have questions you'd like to have them answered, please put them in the Q&A box down below. So the first question is from Marianne, and it is business covered if staff and client signs a waiver to enter your business for service?
This is Mike. I can take that. It certainly would help. It all depends upon what the waiver is, what the language is. But as we say as attorneys, every question leads to another question. You have a waiver like that. Could it be construed to not provide reasonable accommodation to your customers who are disabled or your employees with a disability? Does it discriminate against people of a certain age because they're more likely to have these problems? So I'm not aware of people doing that, and I don't think I would probably not advise my client to do that, except under certain circumstances where maybe the people are going into particular parts of your business or your operation. So that would be one that I would certainly talk to your attorney about, and it might work. It might also turn off your customers and clients.
Thanks, Mike. The next question we have is from Diane, and she's asking, can you ask your employee to take their temperature daily?
This is Mike again. Yes, you can. In fact, you can take their temperature at work, and you can do it daily or more often. You certainly can do that. The question is, what do you do if they have a certain temperature? You have to figure out what your protocol is after that. But I've seen no issues with taking temperature of employees.
Thank you, Mike. The next question is from Tom, and he's asking or stating, there appears to be several sources of guidelines, federal, state, and local. Which one or ones should take priority?
This is Mike again. Tough question. It all depends. It all depends which governmental body really has jurisdiction over your issue. If you wanted to be on the safe side, you would comply with one that is most strict, but that's a pretty tough call. I think you may want to call one of those governmental regulators and try to find out, say, which one should I comply with? That may be on their websites. And if it's a real issue, you probably should talk to your attorney or your trade group. They may be able to tell you, but there are all kinds of overlapping and sometimes contradictory regulations. It's a problem. It's a good question.
Thank you, Mike. Next question. I have had to temporarily cancel my liability and vehicle insurance policies until I reopen in August. Will my insurance carriers drop me or raise my rates because of this?
This is Mike again. I don't know. They won't drop you because you'll have to apply, and they'll just decide. I don't think they will. Your rates may be higher simply because insurance companies are facing massive claims. So I think you'll be able to get insurance, and it may be higher, even though it has no bearing on, the underwriters would have no issues with you creating a liability risk. But if you're trying to get some coverage that may cover claims for or virus-related claims, your premiums will go up. But I haven't heard anything about premiums for, say, auto or vehicle coverage going up, other than everyone predicts all premiums for insurance companies will go up.
Okay, thank you. This is from an anonymous, this is from a gym in Monterey. Can staff refuse hours from home being offered?
This is Mike again. I guess the question is, can you require someone to work at home? I believe you can. It all depends on specifically what their job is, but I believe under these circumstances, you could require them to do it, and you can set their work hours again. So if that was the question, I believe you can.
Okay. This is an anonymous question. Our office is in a building that also hosts many other tenants. What is the landlord's responsibility to tenants and guests entering into the building? Signs or guidelines for all tenants to follow? Or is it a responsibility of each individual tenant?
This is Mike again. It depends on what the lease says, and usually leases are more pro-landlord, and it puts these responsibilities on the tenants. But you'll have common areas where the landlord is responsible, maybe a lobby that everybody uses. And so I would generally say the tenant will be responsible, but under these unique times, no, the leases and the insurance policies may not really have clear application here. So we don't know, but generally I would say it's the tenant, but the tenant and the landlord should work together, because if there's a problem, both of them are going to get sued.
Excellent advice. The next question, what if you have independent contractors? How are they covered as opposed to an employee and the business is covered?
Well, this is Mike again. As maybe you know, as you've been following the news with Uber and Lyft, in California, who is an independent contractor and who is an employee is probably the hottest legal issue there is, and it has not been decided. But if someone is an independent contractor, you don't have any obligations to them as an employer. Your obligations to them and them to you are set forth in any contract you have. Now, having said that, if you have an independent contractor working on your premises and those premises are dangerous, and this person gets hurt or say contracts the virus, they may have a claim against you. But that's why people have independent contractors. They want to avoid having liability to them as an employer, workers' compensation, wage and hour, things like that. So how I always tell people to view independent contractors are just like a plumber coming to your house to fix your pipe. They're an independent contractor. You owe them the obligation that your house is safe, but that's about it.
Okay. Here's one. I have a landscaping company and I was subcontracted by a company, and he's mentioned the company, which I won't. They are responsible for maintenance of commercial establishments throughout the country. During the shelter in place, I notified them that we could not go out to do landscaping maintenance for the 9 banks that I was doing. They just took my job and looked for someone else. This has affected my business a lot. Is there anything I can do?
Tony, do you want to take a stab at that one?
Sure. So in terms of employment, it would depend on what sort of, if you have business interruption insurance or if there's any sort of insurance that may have covered your loss during the interim period.
It also sounds like this is a contractual relationship, that perhaps they're contracted. Yeah, they're subcontracted by a company. So they're saying they can't meet their end of the subcontract because of the shelter in place. And that the main contractor has taken the work away from them and given it to somebody else.
And so this is where the terms of the contract would come into play, what Mike was talking about, the force majeure clause. If there's any sort of way that the company could have gotten out of the contract, or if they were justified in not performing their end of the contract, it would really come down to the language. And so you should have a lawyer review that contract to see if there are any potential claims that you might have against the company.
And this is Mike. As a practical matter, these types of claims are difficult to make, and especially if you're going up against a large, national company. My advice, things like this are usually just see if you can work something back out with them. As I often tell my clients, litigation is not a profit, usually not a profit generator for anyone other than the attorneys. So making a claim like that, I think, would be difficult, not impossible. Depends on why they terminated you. But I would first exhaust all efforts to try to work out some deal with the company where they bring you back. And I'm sorry for your situation. We see it all the time. It's unfortunate.
Next question. Employees are supposed to launder their masks. Do we have to monitor that they do that?
This is Mike. That's a very interesting question, and I hate to say is going to generate a litigation about who has to launder and who doesn't. I think an employer can require that. It's not a big deal. Frankly, I would advise the employer to provide masks if that's an issue, as long as it's not too expensive. That way you don't have to worry about employees laundering them, and how are you going to figure out if they in fact have laundered them? I would say you're better off providing. It may cost you some money, but you're better off providing them their own masks yourselves than requiring them to launder them.
Another question. Can you add some COVID issues to a regular hold harmless agreement, or do you need special wording?
Good. This is Mike again. That's a very good question. You would need special wording, I think, but you could add it to any hold harmless or indemnification clause in a contract. I would specifically put in some language, that you're being held harmless for any, damages, claims, et cetera, caused or attributable to any pandemic, any disease. And here's where you get to the lawyer language, including but not limited to the novel coronavirus, et cetera. If you want that in an agreement, a hold harmless agreement, I would put it in very specifically so there's no argument later on whether it's covered or not. And if you don't want it in there, take it out.
Okay, thanks, Mike. Is it okay to require certain employees to work from home, but allow others whose duties require them to be at the office to return to the office?
This is Mike again. The reason why I'm answering this is I've had to deal with these issues a lot, including at our own firm. We had to make the decision of which employees were essential and which were not, and which could do the work from home and which couldn't. I think you're perfectly fine in telling employees, you need to work from home, and telling other employees, come to work. You can't do your job from home. And if they say, no, I'm afraid, I don't want to, you may want to try to accommodate them just as a matter of being a good employer. But as long as your workplace is following the CDC guidelines to be safe, you can require that employee to come to work. As long as they're not, sick or something like that. And then they have to make the decision what they want to do.
Okay. Another question. Is there any legal liability if a customer states he or she contracted COVID-19 at your place of business?
This is Mike again. It could be. The problem is, how do you prove that? And that's why in the workers' compensation case, the governor realized that's going to be virtually impossible. So they said, we're just going to presume that you got it at work. If a customer comes in and says, I got it from you, certainly, and they want to do something about it, I would certainly call your lawyer and maybe your insurance broker. But just having someone say that isn't enough. They'd have to say, have to have evidence of it. One of your employees who's tested positive, came up and gave me a kiss. So, that's an exaggeration, but they'd have to prove that they got it from you. And that's going to be very, very hard.
Okay. So we don't have any more questions except for where do you post webinars on your website? I can't find past recordings on the website, and are they only available to members? No, the recordings will be sent to you, so you'll have a link to the recording to the events that you've attended, and the past recordings are available on the SBDC website, but they're also, if you go to Monterey County Business Council's YouTube channel, you'll see all of the past recordings there as well. Question was, will the answers given be included in the mailing you do from this webinar? You will have access to the recording, which will have the questions and answers that were given. So that will be your way to access. We're not recording them, and we're not going to record and print them and send them to you. An employee wants to return to, here's another one for you, Mike, I think. An employee wants to return to work when it's safe. She has health issues which were not disclosed when she was hired only 3 or 4 weeks before. What do I do?
I guess the first question is, what do we all mean by safe? No one really knows. If this person, in fact, has some conditions that makes he or she more susceptible, that may be an issue that you have to accommodate her or he for that. So I think here's where you have to get in the weeds. You have to really find out what the issue is. You may need to get some doctor's order or a report for her saying this is, or he, what this person can or cannot do or be exposed to or not exposed to, and figure out if there's some way you can accommodate her or he. And if you just simply can't, you don't have an obligation to fix everything. So it really depends on all the information of exactly what the problem is. And if she just says, I can't come to work at all, you need to know why, and there needs to be some sort of medical evidence to support that, like any other return to work issue, frankly.
Okay. Thank you. The questions are starting to come back in again. We could take a few more. We've set up it to go until 11. Is there anything I can do to prevent an employee from claiming remote work as a reasonable accommodation after the COVID-19 situation ends?
This is Mike again. I don't think so. They could ask, but all employees can ask to work at home, and you can say yes or no. And if there's no reason caused by the COVID-19 why this person can't come to work at home, at work, I think you can say no. There's no reason why you can't come to work. I may let you do it, but I don't have to. You treat it as any other disability. Does this person have a disability, and is it a reasonable accommodation to let them work from home? It's the same question.
Okay. If someone comes up testing positive, staff or participants, I'm sure they probably mean customers, what are our legal requirements? Notify everyone who came into contact, but do we all have to shelter in place due to exposure? Oh, this is from a camp that will be operating this summer.
This is Mike again. Well, I hope you're operating this summer. I think you have to follow the CDC guidelines on those situations. If you have someone that you know has tested positive, I think you then have to follow those guidelines of what you do. It's, you know, who's been exposed to this, and you very well may have to quarantine people. So there's kind of two issues here. One, what are your obligations under the CDC guidelines and rules? And then what are your legal obligations? And your legal obligations are really to do what you need to do to protect your other employees. And that may be telling them, hey, have you been exposed? You've got to be quarantined you can't come to work for 14 days. That's a little bit of difficult issue, and I would certainly check with the CDC and probably with your employment attorney, because these are unique issues which we don't have standard answers for.
All right. We have hit 11 o'clock. In fact, we've run a little bit past it, and we are out of question time to answer. So thank you so much for participating. I want to thank our partners, the Monterey County Business Council, the SBDC team, the City of Salinas, the County of Monterey, the U.S. Small Business Administration, and the California Governor's Office of Business and Economic Development. And again, many thanks to Luis Alvarez of Alvarez Technology Group and the team over there that produced the webinar today. Just as a final reminder, we recorded this webinar and we'll send you a link to the recording so you can review today's class, and we will also send out the contact information for the speakers today. Thank you so much for joining us, and we hope you have a fantastic weekend. Goodbye, everyone.